Hi, good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today's guest is a lawyer, and she's going to talk to you about her book that just recently got published. So, thank you so much, Sayeh, here for joining us today. And perhaps maybe you can start by telling us a little bit more about you and the work you do at the Justice Center there for Constitutional Freedoms, and as well a little bit about your book and what brought you into law in the first place. And we can start with that. Thanks again for joining.
Thank you so much for having me. Those are a lot of questions. So maybe I'll just start with what got me into law, and then we can go into the rest of what I've been doing in the last so many years. I was born in Iran, and when I was the first 7 years of my life was basically when there was a war between Iran and Iraq. So I lived through a war, and then my family had to flee Iran when I was 7 years old. We lived in Turkey for 5 years before we came to Canada. And my experience in Canada was so different from what I had experienced in Iran and Turkey. The rule of law, and I learned about the charter, which I thought was just the most incredible thing because I'd never heard of like legislation or anything that really protects the people against the government. So I thought that was just incredible. And that's really what got me into law. And I wanted to be a lawyer because I knew I wanted to defend people's rights. And I really wanted to do something that involved the Charter of Rights and Freedoms. And so I went to Ottawa University for my law school. I'm originally from Ottawa. And I knew that I really wanted to do criminal law because I thought that's probably one of the things that works best with the charter. And I was lucky enough to get an articling position with Walter Fox, who at the time he was practicing in Toronto. He just recently retired. And so I worked with him for about a year. I articled with him, and I just loved working with him so much because he had so much experience and he was a wonderful mentor. So I told him, you know what, I'm not leaving. You have to hire me back. And he did. And so I was his associate, his only associate, and we worked together for almost 14 years until just the end of last year. And then in January of this year, I started with the Justice Center for Constitutional Freedom, which is also an incredible opportunity because I still get to do charter litigation, which has always been my passion and what I love to do. So that's a
Okay,
little
perfect.
summary about me.
Okay, that's a great overview there, and certainly it's a new start here with the Justice Center for Constitutional Freedom. So maybe you can tell us a little bit more about that role that you've had now for the last few months, and what are the kinds of things that you're doing, and how that's different from being associate in criminal law. It's certainly, even I was in a criminal associate not too long ago before having my own little practice in teaching. But how do you find them being different than what you were doing with Mr. Fox before?
So there's definitely similarities, which I love, and that's the charter and the fact that the charter is always involved in the cases that we do. And right now with the Justice Center, a lot of the things that we do is surrounding COVID and the charter violations and things that are sort of going around the COVID issue. So, for example, I'm right now doing a federal case in the Federal Court of Canada. Uh, Challenging the hotel quarantines, the 3-day hotel quarantine. So that's one of the things that I'm doing, and very exciting case. There's a lot of a lot of our cases are around the churches who have not been able to practice inside because of the limitations, and there's lots of litigation around that, around protests. Because that's another thing where it's very limited right now, and people are not allowed to protest outside. So we've been helping and representing a lot of individuals who have gotten tickets and fines for protesting. Those are the kind of sort of the big ticket items right now. Some of our lawyers did a big 8-day challenge in Manitoba. They just finished up on all of the lockdowns in Manitoba. So a lot of our litigation right now is sort of surrounding the COVID and the restrictions that have followed in the last year and a half. And what is different, I think, and what I love the most about this position is that nobody goes to jail. Whereas in criminal law, I mean, the fact that there's a possibility, and no matter how good a lawyer you are, people are going to end up going to jail sometimes. And that was really hard for me personally. It really like weighed very heavily on my shoulders. And it was my least favorite part of the job. But here I feel like I have the best of both worlds because I get to do litigation and it's all charter related, but nobody goes to jail at the end of the day, and that makes me very happy. And it really, I think it takes the edge off a little bit and takes the stress off a little bit more.
Yeah, that's great. It's sort of getting the best of kind of both experiences there, and perhaps I don't know what much you can share about the as it's in the works there, but I know we've been talking in my class a lot about COVID and a lot of how your rights are affected, and certainly, I mean, number of the different the number of the different restrictions with respect to a lot of things you can do and whether or not that amounts to various charter issues. But we can just talk about the one that you mentioned about the hotel quarantine and kind of what are the things that would come up in an argument there that would impact our charter rights that people may not necessarily know.
I think a lot of people, and I just want to give this broad overview. I think we take it for granted that most people know about the charter and know about their rights, but I don't think that's true. And there's a lot of barriers that prevent people from knowing what their rights are. And so that seems to be an issue with respect to the quarantine hotels. There's a lot of sections that we believe are involved and we're going to be arguing that are being impacted. Section 7, the right to life, liberty, and security of person, because people are being detained against their will. That's the argument that we're making. Section 9, which is the right not to be arbitrarily detained. Section 10b, the right to speak to counsel once you're detained, which is something that people are not being advised of. Then a whole slew of others. So there's section 11, the right of the presumption of innocence, and the right to contest your detention. So if you're being detained and if you're criminally charged, you have a right to go to court within a reasonable period of time, and you have your bail hearing and you contest your detention. Here you have people going into quarantine hotels and sometimes quarantine facilities, which are different. If you test positive, for example, or if you don't have the proper what they deem to be a proper quarantine plan, you're sent to a quarantine facility, and you don't have any right to basically object to it. You can't refuse. There's no recourse. There's no way for anybody to to go to court and to have your detention reviewed. And these are all problems that we are saying these measures are unconstitutional because they violate these sections of the charter.
So it's very interesting, and certainly we'll see how it all plays out at the various levels of court and what the end result is going to be. But you mentioned in there about bail hearings, and maybe it's a perfect segue into your book there, which is a practitioner's guide to preparing and presenting bail hearings. And certainly, maybe you can first of all tell us a little bit more about what goes into a bail hearing and why are people, the grounds for people being detained, and what are the things that a practitioner needs to do in terms of preparing and presenting for a bail hearing, and share a little insight from your book there.
Okay, sure. Yeah, I'd love to do that. And I'll tell you how I got inspired to write this particular book. One day I was sitting in the Superior Court. I was waiting for a client to be sentenced. And right before my client was to be sentenced, there was a bail review going on. And there was a client in the box, we're in the prisoner's box, sitting there looking very defeated. And this lawyer, I could tell he was a newly called lawyer, and this was probably his first time doing this bail review. And it was not going so well. And I thought about it. I spoke to that lawyer afterwards because he was just having such a difficult time and I felt really bad for him. And then I thought, what if there was a resource, something that's really easy to read and sets out exactly the kinds of things that a person who doesn't maybe have a lot of experience needs to do in order to be able to conduct the great bail hearing, great bail review. And that's what motivated me to write this book. It's not a super academic book. It's very practical and it's really easy to read. And what I really wanted to just make sure that there's a resource out there for students, for articling students and newly called lawyers. They can just pick it up and go to the chapter they need. So for example, if they are doing a bail hearing and they've never done one before, they can read all about, what do you do when your client calls you? How do you prepare your client? How do you prepare the surety? what kind of negotiations do you do with the crown. Every single step is set out for you in there in a very sort of a concise and easy to understand way. And I'm hoping, once you read this, you'll be able to do it even if you've never done it before. I know my husband, who's a social worker, is now reading it chapter by chapter, and he's like, oh my God, like this doesn't make sense. And now I know how to do this. And I figure if it makes sense to him, hopefully it's going to make sense to, students and people who are just recently starting out as well.
So maybe we can talk a little bit more about bail hearings. And usually when I have all the different criminal lawyers and stuff on, I kind of look at different aspects that we can look from like the beginning of a matter and certainly all the way to the end. I know you have a lot of experience here writing about bail hearings, but perhaps maybe we can start with, you mentioned there, how do you prepare your client and perhaps preparing the sureties as well for the bail hearing? And, for example, they get arrested, let's say late night, tonight, and tomorrow morning is going to be their bail hearing. I mean, with some exceptions, right, for like guns and things like that, where they'll have the special bail hearings. But let's look at something where, common thing that I work as a telephone duty counsel as a qualifier there. So I get a lot of these calls where, especially in COVID, unfortunately, someone gets arrested for a domestic assault, and they don't realize, obviously, they have to be separated from the other party, and now they're going to have to find somewhere else to stay, and they don't have anywhere else to stay off the bat, so they're being detained until the morning for a bail hearing. And can I maybe walk through the process there? Maybe they have an uncle or their mom or a father or somebody who could be a surety, of how you would recommend there for practitioners to prepare for that hearing if it is in fact going to be contested by the Crown.
I think that you need to prepare your surety whether it's going to be contested or not, because you won't know until the last minute. So it's best you do your full preparation before you go to court. And sometimes it's easier said than done. Like you said, you get a call in the middle of the night and the person is in custody and they're going to be in court the next morning. But I think it's really, really important when you get that call from a client who's in custody, the first thing you need to know is who can you call, who can act as a surety. Do they have a family member, like you said, mother, sister, an uncle? If there's no family, is there a close friend who might be willing to act as a surety? Maybe sometimes an employer. I've had clients who have had nobody, but an employer has come forward and they've acted as a surety. So you really got to explore that right away in the first phone call that you have with your client in the cells, because that's really the only opportunity you're going to have to see if there's any surety at all available for you. And then once you have that, you call the surety. Now with COVID, I guess we all work from home, but before COVID, I always like to meet the surety in my office before we went to court. So if I had to come into the office at 7 o'clock in the morning to meet the surety and make sure that I would prepare them properly and they would be very comfortable. Now it's a little bit different because we do everything on Zoom and the bail hearings are done through phone, which is not my favorite thing because nobody can see each other. And I find that very difficult and dehumanizing almost. Um, but so in terms of preparing the surety, you want to make sure that first of all they know what their responsibilities are, and there's three main responsibilities for a surety. Make sure that the person shows up to court, make sure that they don't commit any other crimes while they're out on bail, and then make sure that they abide by their bail conditions. And I want to know that the surety understands that and they can tell that to the justice of the peace if need be, because that's a pretty important factor. And the second, I think, most important factor is, are they willing to call the police if the person breaches their bail? Because that's really important. And I want to make sure that the court believes if there's a breach, they will call the police. And it's really actually helpful once you explain to the surety that if there's a breach and you call the police and the person gets rearrested, you can still act as a surety because you did your job, you called the police, so the court can trust you. Versus if you don't call the police and the person is arrested, now you've eliminated yourself as a surety, the court is not going to trust you, and maybe there is no other surety available. So it causes some serious problems. Those are definitely two things that I think needs to be covered. And then, of course, the plan. What is the plan? Is the person going to be living with you? Do you know what they're charged with? what's the work situation is going to be like, what's the supervision going to be like. You want to make sure you have a very, very detailed plan. And once you have that, you can negotiate with the Crown before the bail ever starts. And maybe if it's not a super serious offense, the Crown might consent because they see that you have your surety ready, you have a great plan, and then maybe you don't actually have to do a full bail hearing.
That's great there. And is a surety always going to be something that's required there in terms of securing someone's release, or are there any other opportunities? Because a lot of times someone tells me I don't have any family here. I mean, using the example we just had as a domestic situation, well, that would be the only person I would contact, and obviously they can't be my surety. So what do you do in those situations?
It's tough, and I have a chapter on access to justice because I feel like when you have a person who really has nobody that they can rely on, nobody that they can call on, that goes under access to justice. And how do we treat people? Maybe there are people who have addiction problems and they've just, committed so many petty crimes to feed their addiction, and there's no longer any family or friends who's going to come forward. But this person is still a human being, and they need certain not only treatment, but they need a way to come out because they're not committing serious crimes. They're just like very petty crimes, or somebody maybe who doesn't have family. And I wrote a whole chapter on access to justice. And one of the things that you can do is there's a bail program available. So if you have no surety and nobody that you can count on, the bail, and it has to be something that is not super serious. So it can't be like a high level crime, but maybe like a domestic or I don't know, theft, anything that's not super serious. You can, as a lawyer, you can refer them to the bail program, and the bail program will interview them and then see if they will agree to certain terms. And if they do, then the bail program will essentially become their surety. And then that's another option for people that really have nobody else. But there definitely needs to be more, I think, in terms of mental health support, which we really, it's rare. And in terms of people who are releasable, but unfortunately, there's just maybe they don't have an address, they're homeless. There needs to be more. And I think that's why I wrote that access to justice chapter. And I think it needs a lot more conversation, and hopefully we can come up with some better ways of dealing with these situations, because it's really painful to watch. I mean, I've sat in bail court for full days, and I've seen in drug court, and I've seen all these people who are just, you can tell they have serious problems and they need help, and there is really, they don't have a lawyer, they can't afford a lawyer, there's no mental health person there, and it's just the support is not available. And so it just creates this cycle where, you come out, you commit a petty crime, you go back in, and then it just continues on.
And maybe we can touch on this as well for my students. I know some of them we covered this in criminal law, and some of them haven't learned it yet, but there are 3 grounds, obviously, that you can be detained on. And kind of, first of all, maybe you can talk about what they are and how, as a practitioner, you can overcome those grounds if they're being alleged by the Crown. I mean, I know generally, there's going to be specific examples every time, but generally, what are some ways to overcome those 3 grounds?
So the first ground is the primary ground, which is it basically the court wants to know you're going to come to court, you're going to show up to court. And if you can show that this person has roots in the community, so they have an address and they have a job, they go to school, they live in this community, usually that's not a ground that is of concern. But it does become problematic, of course, if you're homeless, for example, and you don't have an address. How do you address, like how will the court know that you're going to come back? And so bail program is one of them, one of the possibilities that they can sort of keep track of you. I saw a very unique situation once in this bail review that I was talking about earlier, where the lawyer was doing it for the first time, and that client was sort of in a similar situation, and the judge basically ordered him released, but that he had to come back to court every 2 weeks and report directly to the judge, which I had never seen before. But I just thought that was such a great creative way that the judge kind of took control of the situation and released somebody who was releasable, but still with some, control over the person. It can become difficult if there's no address, but if you have roots in the community, that's not a big concern. Usually, that's not something that the Crown is concerned about. Secondary ground is the concern that you're not going to reoffend and you're not going to do the same thing again. And it becomes a serious issue, for example, in domestic assault cases, where the Crown is very concerned that, if this person is released, they might go back and they might, assault their partner again. So that it's a serious issue in sexual assault. It's things like gangs and guns and offenses that are very serious. And depending on how serious the offense is, and also what type of offense it is, you have to sort of design your bail plan to address the issue. So for example, if it's a domestic and the Crown is very concerned about, the person contacting their partner again, you want to have a very good surety. You want to have a supervision plan so the surety is able to, supervise them from this hour to this hour. And if they're not at home, there's a cell phone and they can be in touch. I've had clients who had family members who lived in another city and they just kind of took the accused and took them out of the city completely, so that there was no concern about the person contacting the domestic assault, the domestic partner. In more violent crimes like guns, gangs, you want to have a very strict plan, maybe even offer house arrest where the person stays at home at all times. That's going to be a lot better than having to stay at jail. So depending on how serious the offense, you want to have a very well tailored plan that ensures the person does not commit any further offenses. And then the last one is tertiary grounds. And that used to be very rarely used because it was for like the most serious types of offenses, something that would really like shock the conscience of the community. But I have found in the last 5 years or so, it's used like very regularly. So it's made bails a little bit more difficult, I think, but there's a way to overcome that as well. So one of the ways is you can look at how strong is the Crown's case. Is there a lot of evidence against your client, or maybe it's just like a circumstantial case? If you can show the justice of the peace this is not a strong case, that helps you with tertiary grounds. The plan that you have always will help as well. But these are just some of the things that I can think of off the top of my head that would help you with overcoming different grounds of bail.
I think those are some great tips there for young practitioners or any practitioner there with the bail hearing. Now, another thing with bails people don't realize, obviously, is there are a number of conditions placed. We were talking about supervision plans, things like that. But what happens if the situation changes and you need to now get a variation to the bail conditions? And how does that process work? And what happens if the Crown or whoever is not available or doesn't want to consent to a change in that condition? What do you have to do then?
Okay, so to change the bail, I think the first thing to do is you're not going to be able to do it right away. And that's something that we have to tell our clients, like, you don't come out today and then we change your bail tomorrow. It takes time. And I always advise the client, be on your best behavior for the next, let's say, 2 months. Do everything to the T. Do not breach. Just be on your best behavior. And then 2 months down the road, I can go to the Crown and say, look, my client has been on his best behavior and just done everything right. And now we want to change. For example, let's say if they're on a curfew, we want to remove the curfew. Because the client has been on their best behavior, and if I can give a reason why we want to remove the curfew, let's say the person is going to be working nights, that's going to be really helpful as well. And then the Crown is most likely going to consent. Versus if on your second day you go and you breach your bail, not only are you not going to be able to change your bail, you're probably going to get breached again and get charged again. If the Crown doesn't consent, you can always bring a bail review in the Superior Court. That's a little bit more onerous and a little bit more difficult to do. So my recommendation is always like make sure your clients are on their best behavior, get them to do some volunteer work in the meantime, some charitable donation, anything good that you can sort of collect in a folder and give it to the Crown and say, like, look, this guy's done so many things. Can we change this bail condition? It's easier, it's less onerous, and it's usually 99% of the time it'll work as long as it's a reasonable request.
Now we were talking about bail reviews there when you were telling us the little story there of the young lawyer who was struggling with one. How is preparing for a bail review different than preparing for your ordinary bail hearing at the Ontario Court of Justice?
The bail hearing is a lot more hands-on because you're preparing your sureties, and there are more people involved. You want to make sure your sureties all are ready and able to give evidence. And then there's a lot of negotiations with the Crown before you actually start your bail hearing, because maybe you can get a consent. Bail reviews are a little bit more academic and they're based more on legal arguments. So you don't necessarily have a surety coming and testifying at a bail review. You can in some cases, but generally it's much more legal based. And so your focus would be on case law, I think, and making legal arguments, versus in a bail hearing, it's just a lot more practical and you're dealing with your sureties and how to best present your sureties and the bail plan.
Okay, and maybe we can touch a little bit more on preparation for the bail hearings then, because certainly you're going to be doing a lot more bail hearings than bail reviews. And maybe you can share, and perhaps in your book as well, kind of what are some of the mistakes that young practitioners may be making in terms of preparation or presenting at a bail hearing, and then what are some solutions to overcoming those mistakes?
So I think the number one, I don't know if we call it a mistake, but one thing that I've seen that it can definitely be improved is lawyers that don't know the facts of the case. I mean, I can appreciate that sometimes as lawyers, we don't know a certain case. We go and there's an issue arises and we're not familiar with an area of law, and we can ask for an indulgence to go look at the case. But you got to know the facts of your case. So for example, let's say your client is out on a bail already and they've been charged again, you better know what conditions they had before. Or if your client is on probation, you need to know, what were the conditions of the probation, when did they go on probation. These are the facts that you have to know. And I have seen lawyers who did not know this, and it just does not look good for you and it's not helpful for your client. So know the facts, really important. And the second thing is prepare the sureties, because you do not want your surety to go up there and say something that is completely wrong and completely going to hurt your case, and you're not going to get bail. So make sure you ask all the hard questions in your office and make sure your surety is ready to go. And then be nice to the Crowns. I mean, the Crowns in bail court are working so hard. And I've done some duty Crown work as well in the bail court, and it's really, really difficult and they work really hard. And I think it's really important just to be cordial and be early, make the effort to speak to them to see if there's a way of resolving the matter or getting a consent, because the Crowns are not our enemy. They're doing their job, we're doing our job, and they work really hard. They work as hard as we do. So I think it's really important to have that mutual respect uh, for each other.
Now, certainly in terms of preparation, and as we were highlighting, a lot of times you don't necessarily have the benefit of time. You get a frantic call late at night and you need to contact potential sureties right after and tell them to be ready. But I mean, one thing that is different, maybe we can talk about it. Obviously, you mentioned the bail hearings over the phone now with COVID, as opposed to having to bring people in person. Now, I think there's the trade-off though, right, is, I mean, you get that dehumanizing aspect, as you mentioned, but you also maybe not have to get people to come from far away to one courthouse in the area that would have been impossible for a surety otherwise, right, that they can be available on the phone. So maybe you can share a little bit about how bails are operating now in COVID times, and what's kind of presented new challenges, as you said, and certainly what are some things that we can benefit from and maybe keep doing in the future?
Well, I do like, and I think I agree with you. So, in terms of access to justice, a lot of the families and people that are in the justice system don't necessarily have the means, for example, to have a private car to come to. In Toronto, we have to go to 2201, like, for example, to do a bail hearing, which is really far away in the middle of nowhere. And not everybody is able to do that. Not everybody is able to take time off from work. I mean, we take it for granted that somebody can probably take the day off from work and come and access a surety, but not everybody has that luxury. So being able to do it on phone, it is a little bit easier, I think, in terms of, you don't have to do the travel, and maybe you can take an hour from your work and go into a room and, do it rather than having to travel to court and back. But I don't know that, I mean, I don't know if the write-off is worth it. I don't know, because it is dehumanizing. Even as a lawyer, I find that when I can't see the justice of the peace, I can't see the crown, I don't really know what's going on. Like, I really have to just be speaking and asking, like, are you there? Is the justice here? And what's going on? I can't see anyone. I find that very troubling. I mean, part of, I think, our legal system is the transparency and the formality of it, even, which I appreciate personally to have, because it's serious business. I mean, people are going to jail. We're dealing with serious things, and doing it on the phone, it seems very informal and dehumanizing, and I don't know. And not everybody also has access to technology, which is another problem. If you don't have um, the phone, if you're an elderly person, you're not familiar with technology, those are kind of problems that come up as well. And we take it for granted that everybody has a phone and everybody has an internet connection and a computer, but that's not the reality for a lot of people. Those are things that I think we need to keep in mind.
And are they doing any on Zoom or anything like that, or is it predominantly on the phone, or just depends on the location of where it happens?
Well, up to end of last year, it was all by phone. I'd never done one by Zoom. And as I was doing my per diem work, that was by phone as well. And it was very challenging both ways. So I don't know if things have changed in the last 5 years, because the last 5 months, because I haven't done any bail hearings, and I don't know if they're via Zoom now. But that's not great either, again, because we take it for granted that everybody has access to internet and a computer, and that's not a reality for so many people. And that doesn't necessarily help with access to justice. I don't know what the solution is, though. I mean, I see that there are issues, and I'm not sure how exactly we can address them.
This is great here. We're talking quite a bit here about bail, and I know it's really helpful for those who are doing bail hearings or wanting to know more about how the system works. But another thing, I guess, with respect to bail hearings that does tend to come up is, in terms of some of those conditions, in terms of maybe the financial amounts that sureties may have to pledge, or maybe even just talking about, I think a little bit of a misconception sometimes is people, and I often get the question as duty counsel in the night, I don't have $5,000, or I don't know anyone who's going to be putting up $5,000. So maybe you can explain how that works out with respect to sureties and the bail money, as people kind of know or see on TV, or especially the US shows with the bail bondsmen and things like that.
It's not quite the same as the TV shows, but the law is, if you're releasable, then you have to be released, and they can't put an amount on your release that is impossible for you to accomplish, because that means you're really being detained even though you're releasable. So the way that it usually works is, and this is part of preparing your surety, is you have to ask them, what's your income? Do you have any savings? Do you have any assets? And you put all this information before the court. And if you have somebody who owns their home and maybe they have $150,000 in the bank, then the court can, put up a higher amount, versus if you're putting forward someone who's, paycheck to paycheck, and maybe they only have $300 in the bank, then there will be a lower amount set. But it kind of like, if you don't have a lot of money, if you're paycheck to paycheck and there's a $300, for example, bond that you have to pledge, that's a lot of money for you. So that will keep you honest, and that, the surety will ensure that the person doesn't breach their bail because they don't want to lose their $300, which is really important for them. Versus if you have a lot more money, then the bail might be higher. And it just depends on what your income is. And it's your job as a lawyer to make sure you put all of that information before the court. Does the person have assets? Do they have money? Do they have savings? So that the court can make a reasonable decision on what the bail should be.
And in terms of, we talked about preparing sureties, but and so as well, the client, is there ever a situation where you would have the client be taking the stand in terms of securing their own release? And how do you prepare them in case they're asked questions from the Crown, maybe related to the incident, right? Because at that point, anything could potentially be fair game, or even from the sureties, right? If they're like, oh, but little Johnny told me, he didn't really mean it when he stole the bike. It was, he was just being dared by a friend. And you're like, okay, well, now trial counsel is going to be a little upset with me, even though I may have potentially secured the release for this individual.
So in terms of the client, I would not recommend ever putting them on the stand because, like you said, the Crown is then able to cross-examine them and they might ask some questions that are not going to be helpful for the case. If there's some particular information that you want before the court that your client has, maybe you can take that piece of information and put it through the surety. For example, where does your client work? I'm just giving you an example off the top of my head. Instead of having my client give that evidence, I would either ask the surety to put that in front of the court, or I would just make in my submission saying that this is where my client works. But I would not put my client on the stand because you're not going to have any time to prepare your client either. I mean, they've been in custody. You're going to be doing the bail on the next morning. There's not going to be time for any preparation. And I can't personally think of any time where it will be helpful for your client to give evidence at a bail hearing. And in terms of the surety, well, that's where your preparation comes in. Hopefully you have covered everything with your surety and they know what to say and what not to say. And what I like to do is I like to prepare and cross-examine them myself and ask them the most difficult questions that I think the Crown will ask, so that it's always harder with me and it's always harder in the office than it is when they're giving testimony because they've already been through the entire thing.
Perfect. So again, I really appreciate that. We've gone over quite a bit here about bail hearings and preparing for bails, and I think hopefully very useful for my students and anyone else listening, as well as certainly they can go and get a copy of the book there for further information. I did want to spend the last little bit of time here talking about a couple of other things here. Certainly, I know you've written articles there as well. On the other end, right? We start with bail hearings, and then the last piece in the process, outside of the appeal, certainly, is sentencing, right? In the event that a client is convicted, unfortunately, then you're looking at potential sentences involving custodial sentences, or if it can be served in the community. I know you had written something, I think maybe last fall, about pre-sentence reports, and a lot of times they're very broad, right? And then it could be the one that they write about client A, they can change the, it's kind of like a boilerplate template there, right? And then they just change a few things and it's about client B. What can we do about kind of, again, preparation as well for practitioners in terms of sentencing, what they can do to hopefully alleviate their client going into custody if that's something that's on the table? And again, different charges, different circumstances. We know that everything is unique, but what are some kind of tidbits that you can share about that process?
Sentencing actually was my favorite thing to do. I love it because it's telling the story of your client to the judge, and I love that aspect of it. And I have never ordered a pre-sentencing report. I just think they are not helpful at all. If it's a good pre-sentencing report, it's just going to be, like you said, very broad and general and not helpful and super short. And if it's a bad one, it's going to have so many bad things in there that you have no control over. And what I like to do is I prepare my own sentencing material from scratch. So I will have, has this person done any volunteer work, for example? I'll put in whatever they've done. Have they done any charitable donations? Have they taken any courses? Let's say the person is charged with assault. I'll send them to do some anger management, and then I'll have that course, in my binder. anything that can sort of portray the person in a positive light to the judge and makes them a human being rather than, just another number and another name. I'll make this big binder with all of this information, and then I will dig in from, the time that they were born until the point that they came, before the courts. I'll have their entire history, and then I'll tell a story of, who this person is, and then I have all of this wonderful material to present to my client, to the judge. And I have this one example, I must share it, because I had this young guy. He had just turned 18 and got charged with something very serious. He was looking at about a year of jail, and he was a coach for basketball coach for like little league little children, and he had gotten all these wonderful thank you cards from all these kids that he had coached. So I like put together a whole collage of all of these cards, and I put it in front of the judge, and I actually kept him out of prison and without a criminal record. He got a conditional discharge because of that material that we prepared. So you can be really creative, I think, and just find as many wonderful things that you can about your client and put them all together in a package and tell a story rather than just going mechanically through the pre-sentencing report, which is what everybody does. And I think when you do that, it really sets you apart as a lawyer, and the judges will remember you, and it helps you build your own reputation as well. So not only does it help your client, it'll help you in your practice as well.
That's great. And I think certainly sentencing, there's a lot at stake, right? In terms of they could be, their entire future really depends, because now, you mentioned certainly coaching, but any job he'd like down the road, he now doesn't have to check off the box, has a criminal record, right? So again, a lot is at stake, and certainly that's why in terms of advocacy, a lot is riding there. So you got to make sure that you present your client in the best light that you certainly can do so. Now, you've had, before you just started over here in January, you certainly had a number of months there doing things like that in terms of with COVID. And I know we were talking about telephone bail hearings. And what about, in terms of trials and sentencing and set dates and a lot of things that are happening, and certainly even what you're doing now in terms of arguments, like appeals and applications, being done remotely. Now, I've been teaching over the last year and a bit remotely and trying to teach students how to be better advocates. It's already a challenge, first of all, being in a platform like that, but then to use it to say, well, guess what? You're going to be potentially doing this a year from now, 2 years from now anyways. What can you share from that experience, from those experiences that you have in terms of being a better advocate, whether it's via a trial or whether it's an appeal that's going to be argued?
It's definitely harder, I think, because in court you have the presence, like you're there and you have a presence. It's more difficult to do it when you're on Zoom. It's more difficult. But I think it's still very doable. And like one of the things that I personally like to do is I don't like to read. I find that a lot of lawyers just read their arguments, and when you're on Zoom you can really tell if somebody's reading versus like if they're speaking to you, and that makes a difference. So, and I appreciate it's not always easy to speak versus read, but preparation. I think if you do it enough and you can sort of speak to the judge rather than read off of your notes, that to me that makes great advocacy, and it really makes a difference. And I know, like when I'm arguing something and I see what the other lawyers are doing, if they're reading and they're kind of monotone, I myself kind of lose interest, and I figured probably the judge does as well. So don't be try not to read, try to speak to the judge, because again, we're telling a story when we're advocating, and we want to convince the judge to agree with us. So it's more like a conversation, I think, rather than just kind of reading. And don't try not to be monotone, have some depth to your tone, depending on what your argument is. I think those kinds of things make a difference when you're doing things via Zoom. I do appreciate the fact of, like, I guess one of the things I do appreciate about the fact that we're on Zoom is that I can do a case pretty much anywhere now in Ontario and even like in other provinces, Saskatchewan, and I don't have to be running around. So that's something that as a lawyer I appreciate, because I do have access to the tools that I need to be able to do that. So I think it's made things easier for lawyers, maybe not necessarily clients. And the fact that we can now file everything electronically versus before we had to have, these huge filings, 3 copies, 5 copies, and we had to take it to each court. Those things, I think they've been great improvements for lawyers, and I certainly hope that they're going to continue because they make litigation a lot easier.
Now, great with respect to some of those tips there about being in the Zoom era. And we were just talking about sentencing, but unfortunately, I mean, sometimes clients will get convicted and sentenced to a custodial sentence. And I know you were talking a bit about COVID kind of really highlighting in terms of segregation, right? In terms of if they're gone to solitary confinement and the impact that has on prisoners there with respect to their mental health. And perhaps maybe you can share a bit about that in terms of what you were writing about and what we need to be concerned about, especially with us getting a little, I mean, it's certainly nowhere near what prisoners have, but a little bit of that isolation ourselves and what it's like in solitary confinement.
Yeah, I think we've at least I have really appreciated that a lot more, especially last year from March to June. Like I was at home all the time, and there was this fear that we can't really go outside. And I think a lot of people were very fearful, and we were just essentially home all the time, except maybe if we went for a walk. And uh, that kind of reminded me of house arrest because when you're under house arrest, you're in the same situation and you can't leave your home. And a lot of people are, will say, well, house arrest is nothing and, it's a get out of jail free card. But when you're actually now living it, as so many of us are, I think we've developed a new appreciation for the fact that, what, house arrest is an actual sentence and it's pretty serious and it can really harm our mental health. And in terms of the segregation, I mean, prison is bad under any condition in Ontario. It's not a good place to be. And with COVID, there's so many more restrictions. For example, like you said, when you go in, they're going to segregate you for 2 weeks to make sure that you don't have COVID. But there's suspension of, visitations. There are no programs available because nobody can go into the jails. So it's so much worse than it was before, and before was not good to begin with. But judges are taking that into consideration when they're sentencing people now. So, maybe if your appropriate sentence was a year, you might end up getting 8 months because of all the difficulties that COVID has brought about. So it is a factor that is considered in sentencing, which I think is a positive step.
No, we just talked about mental health there for people in custody and people under house arrest, and certainly lawyers and in particular maybe criminal defense lawyers who have a lot of stress given what's at stake there for their clients and many long hours. What can you share? I mean, having gone through, we're all going through here the last 14, 15 months now of living with a lot of restrictions and I mean, missing sort of that social time that, going into court would have been, you get to see some of your friends or colleagues who have other matters. Any advice there in terms of for my students in terms of taking care of your mental health, especially entering into a profession where, again, there's a lot that's riding and, where a lot of lawyers end up having, high addiction rates for a number of different things as a result of as coping mechanisms. So anything you could share that's worked for you or from others in terms of managing in the COVID time and beyond?
Yeah, definitely. Especially criminal law, it's very stressful, and I was coping with a lot of anxiety. What I found very helpful is I discovered yoga, and it might not work for everyone, but I was somebody who just did not like to exercise. It was just not for me. And 3 years ago, I found yoga, and what I really liked about that was it's not just you're not exercising. It really engages your mind as well as your body, and I felt that that was really helpful for me. So I make it a point. I try to do, even if it's 10 minutes a day, I'll do my yoga when I get up in the morning. Like it's my thing and I'll do it. And it always makes me feel so much better. And that might not work for everybody. I think as long as you have something that is not law related that you can do at some point during your day. So that could be art, that could be just going out and getting fresh air, because sometimes we lose track of time and, we're in front of our computers till 7 o'clock, 8 o'clock, and we haven't even gone outside to get any air. So just taking a walk really can help your mental health. Whatever it is, reading, I do love to read as well. I'm obsessed with Russian literature. The last 2 years, that's all I've been reading. So if you have something like that, that can keep you busy. But just make sure you have something, anything at all, that is not law related, that you can do every day. And also don't go it alone. There's a lot of people out there who are, able and willing to help you and support you. So if I have a rough day, I'll go to Mr. Fox, who I'm still like in contact with. We always have our bi-weekly Zoom calls. So if I'm having a rough day, I'll talk to him, or to my colleague, one of my really good friends who's also my colleague, Hannah. I'll speak to her, my husband. We don't have to do it all alone, and we don't have to keep it inside. And I think it's really important to have another lawyer who will understand what you're saying. So I could speak to my husband. He might not necessarily relate because he's never been in that situation. But if I'm speaking to another lawyer who's also had a terrible day in court at some point, then they'll know what I'm talking about. So definitely try to get a friend, a mentor, somebody that you can go to and you can talk to, so you're not doing this on your own, because that can be really crushing, I think.
It's some great, very helpful tips, and hopefully they resonate with some of my students there. Again, people have different things, as you mentioned, that will help. But if you find whatever it is to take that time, it's certainly going to go a long way. One of the other things we've been talking about quite a bit over the years, so I've been doing this, is in terms of, in our profession and diversity. And I think you were sharing, your story there from coming from Iran and having to move, and then eventually coming to Canada. We're talking about the rule of law, and certainly now you're working for constitutional freedoms there about our charter rights. And it's important there that we look at the different perspectives and the different backgrounds that people have. I mean, whether it's racial diversity, whether it's gender, whether it's disabilities, Indigenous people, right? I mean, so many different things there. But in terms of diversity in the profession, what have you seen kind of since your days in Ottawa, and what can we kind of do to sort of ensure that, especially in what you're doing, right, in terms of voices, in terms of charter violations that might happen? What can we kind of do to strengthen our profession here, so that we can see more diverse voices kind of being at the table and sharing their stories, and being involved with opportunities to be involved in the justice system?
That's a good question, and I've thought about it a lot. I don't know. I personally don't like to think about myself as diverse. Like, I like to refer to myself as a lawyer and a criminal defense lawyer and a justice center, charter litigator. That's really like my identity. In terms of diversity, like, I see a lot of diversity in the bar, and I've been practicing for 14 years now, and maybe there wasn't as much in the beginning, but in the last 5 years, I have seen quite a bit of diversity in the defense bar, which is really, really nice to see, and in the Crown's office, which is also really nice to see. So I think we're getting there, definitely, and that's a really good thing, just a really good positive thing. We're seeing that on the bench as well. So I think we're moving in the right direction. But I don't know, when it comes to me personally, I think what is important to me as a lawyer is competence. I think that's the most important thing for me personally. I want to be competent, I want to be really good, and I want to assist my clients in the best way that's possible. And that's where my focus has always been. But certainly, I think diversity is really important, and I've seen quite a bit of it in the last, 5 years probably, which I think is just wonderful to see. And I really encourage people. Don't let, I don't know, your past or any sort of difficulties that you've had in your life, don't let it stop you from achieving what you want to achieve. Because I think in Canada, you can do anything you want to do as long as you're passionate about it, and as long as you work hard and you're able to work towards it. I think I'm an example of that, because of everything that I've been through, and but this is what I wanted, and here I am. And I think don't give up, just work for what you want, and you will get it. I'm sure of that.
Perfect. So Thank you so much, Sayeh, here for taking the time to join us and share a lot about bail hearings and everything else that we've talked about. Perhaps give any final words of wisdom here for my students who are listening and anyone else that is tuning in about kind of just what you were talking about there under the lens of diversity. But in terms of making that transition from being students to then practitioners and then thriving in the industry, any words that you can share? And so you can tell us a little bit about if anyone wants to get a copy of the book or if they want to connect with you and learn more about what you're doing there at the Justice Center. Well, we really appreciate that as well.
Yeah, wonderful. And thank you so much for having me. It's been a pleasure. In terms of sort of transitioning, I really recommend finding somebody in the profession. When I was transitioning, I did not know any lawyers. I had no idea what being a lawyer was like. And because I was so painfully shy, I never really like went out to try to find someone who could help me. But I feel like it could be really, really helpful if you find somebody who is in the field that especially you're interested in, that you can talk to and find out about, what's your day really like. And I find like making these connections can always help you with your career as well. It's just really nice to have somebody that you can go to. So mentorship, I find it's really important. That's my number one tip. And number two, follow your passion. Don't do something that you think you should be doing. Do the one that you're really, really passionate about. And if you go for that, you're going to find the job and you're going to get the money and everything is going to work out. Just go with your heart and what the area that you really want to do. Those are the two things I think that are really important. In terms of my book, you can get it on LexisNexis, and I really hope that it will be helpful. The reason I wrote it was because I didn't see any resources out there for students who could, just read it and then be able to apply. The books that are out there right now for bail, they're a lot more academic, and I think you really have to be an expert in bail to be able to use those books. You can't just sort of pick them up and figure it out. It's more difficult. And if you want to contact me, I'm on LinkedIn, and I've had quite a few students reach out to me over the last few years, and I'm generally like happy to speak to you and give you, 15, 20 minutes and talk to you about law and maybe, give you some advice or some ideas about, what to do or not what to do, but, like how can you maybe make connections in the legal field or any other questions that you might have. I'll be happy to do that. So you can just reach out to me on LinkedIn.
Perfect. So thanks once again. I wish you all the best with everything. Really appreciate you taking your time here and talking to us. And thanks to everyone for tuning in again. And hopefully we see you again tomorrow at 5 o'clock. Take care, everyone.
Thank you so much.
Thank you so much, Sayeh. Thanks, JP. Have a great day.